thank you for joining us for our November KeyBank Workshop Series. We're so fortunate to have KeyBank as our sponsor of this amazing series that we do on a monthly basis, sometimes twice a month. So thank you, Sam, for joining us. Nabir, we appreciate you guys being here today for our Pay Equity Law Workshop. I'm going to turn it over to Sam to do some opening remarks. Again, if you guys have any questions at all, please use the question and answer or chat function at the bottom, and we'll get to those at the end of this workshop. Thank you again for joining us this morning. Sam, over to you.
Thank you. Welcome everyone to the Chamber Small Business Workshop Series. I am Sam Staley. I'm the branch manager at KeyBank in our Centerbrook office. It is an honor to represent KeyBank at today's session. KeyBank has been sponsoring this workshop series for the Chamber for several years now, and because we see it as an extension of what we do for financial wellness of our small business clients every day, like the Chamber, we view our role in the community as a strategic partner to business, helping them prosper by providing quality banking services to meet their financial needs. As a branch manager, I work with the small business in our community every day on ways we can effectively manage operations and grow their businesses. Our Small Business Financial Review is a proprietary award-winning review tool that helps us guide conversations with business owners, helping them to identify goals and build a plan for business success. If after today's presentation, you're interested in learning more about KeyBank Small Business Solutions, I'd be happy to set up an appointment time to speak with you. I can be reached through the Chamber. All my contact information is there. So getting on to today, it's my pleasure today to introduce today's guest speaker, Jonathan Bechtel from Stanfield Bechtel Law, located in Middletown, Connecticut. A major part of Jonathan's practice focuses on advising employers of all sizes on various labor and employment issues, including hiring, discipline, and termination. This includes assisting businesses to draft policies and procedures, employee handbooks, performance improvement plans, and the like, as well as handling litigation for clients related to a wide variety of employment matters. Recently, Connecticut passed a new pay equity law requiring all employees to disclose the wage range to open positions to both applicants and existing employees. This presentation will focus on the new law, which went into effect on October 1st to help employers understand their obligations to ensure compliance. Please welcome Jonathan Bechtel to present the workshop for pay equity law.
And thank you very much for the introduction, and I appreciate being a part of this series. I was in the Chamber actually meeting with a few folks over there and was chatting with Danielle, and she informed me of this, and it was definitely something that I was interested in getting involved in, and think it's fantastic that you guys offer this for the small businesses. Helping small businesses survive is one of my passions. So it's really my pleasure to be here this morning. So we're going to chat a little bit about this new pay equity law that's gone into place and give you guys some background. But the agenda for today is pretty straightforward. I'll give you a little background. That was a wonderful introduction about who I am. You pretty much nailed it as far as the employment aspect of my practice. A brief overview of some recent employment laws that have come into place, and then this Public Act 2130, which is really the primary focus of our conversation this morning, practical implications that it's going to have for the employers that are listening today, and then obviously we'll field any questions at the end that you guys may have. So who I am, lifelong Middletown resident, grew up here, went to St. John's on the north end of Main Street, went to Xavier High School in Middletown, and am thrilled to be back in Middletown working. We recently just moved our office down here, and so it's exciting to be back down on Main Street. Prior experience with national law firms, that's really where I got the bulk of my experience in the labor and employment law, and decided that really it was in my best interest to do something a lot smaller. It's myself and Sandy Stanfield, we're the attorneys in the firm, so you really get a personalized experience with us. Various practice areas. Employment is my primary focus. We also do personal injury and professional malpractice. But with the employment law aspect of it, Sandy and myself represent both plaintiffs and defendants. The bulk of my practice is focused on employers and making sure that they're in compliance with the maze, I'll say, of Connecticut employment laws that are out there and the national laws that apply to businesses. Of that, I would say probably 50% of what I do is just general advice, small and medium-sized businesses on what their policies are, making sure we're up to date, drafting, redrafting, doing incident investigation, and like we said in the intro, hiring, discipline, termination, and just advising employers on the way to go about various issues that might arise to help keep them out of potential litigation. Ultimately, that's the goal, is to make sure that folks have a resource to go to if a question arises so that they can make an informed decision and hopefully avoid a potential, bad result as depending on what decision that they make. So a little bit about who I am, certainly happy to chat with anybody more. You've got my contact information. But what are the laws that we're really dealing with? Connecticut is considered, with California, one of the most employee-friendly states in the country. We're constantly enacting, updating laws to help make sure that we're a good place for employees to work, and what that requires of employers is making sure that they're up to date with all of this various stuff. 2018 was a big year for employment laws in Connecticut. Quite a few things started to happen in 2018. Most notably, our Connecticut Fair Employment Practices Act updated our sexual harassment laws, requiring training, reporting processes, and things like that. We've had an update of our minimum wage laws. As I'm sure many of you know, the minimum wage is going up each year over the period of the next 4 years. And I think I saw that there's going to be a KeyBank series on the legalization of marijuana and the impact that that's going to have on employers. That's going to have a major impact on folks. And then the paid family medical leave that's coming into place as of January 1st, 2021. And I'm pretty sure I saw, correct me if I'm wrong, Daniel, but I think I saw that there's going to be a KeyBank series, or there was a KeyBank series on that law as well, which a lot of folks have questions about how that's going to implicate them and what they're going to need to do for that. But for purposes of today's presentation, we're going to focus on the pay equity things. But I thought it was important just to give everyone a quick overview about what has happened as of October 1st, 2021. This pay equity aspect of things that we're going to chat about this morning is not the only new law that's gone into place as of 2021 or October 1, 2021. And there's a number of things that we need to be cognizant of. And I've got them just listed here for you as quick reference. Many of you have probably heard of the Crown Act. It's an act which prohibits discrimination on the basis of natural hairstyle. We've updated some of our age discrimination acts, and now it is against the law to ask an applicant their date of birth, how old they are, even years they went and attended school, to try to combat some age discrimination. Leave to vote, giving people time to go and vote. And then the last one is the act concerning the disclosure of salary range for vacant positions. And that's why you guys have shown up this morning to hear what that entails. And so we'll dive into that here with kind of a brief, just kind of what the history is, what the laws are in the state regarding pay equity, what you need to be aware of, and how those things are changing, how this landscape, so to speak, is changing moving forward. So Connecticut has an Equal Pay Act, and what it had said prior to October 1, 2021 is essentially equal pay for equal work on the basis of gender. And that is a pretty standard act across the country. It varies between equal versus equitable, and what the difference between equal versus equitable is, and the definition of all that. Luckily for you guys this morning, I won't go into the nuance of equal versus equitable because it doesn't apply to us anymore. But our Equal Pay Act requires, based on gender, equal pay for equal work. Now, an employer can justify wage differential. That doesn't mean $15 an hour across the board for everybody. You can have a seniority system, a merit system, quality and quantity production, type metrics, and education, training, and experience. All of those things an employer can use to justify why one person who's in a similar position's wage is different than another position. That was the landscape up until October 1st, 2021. Equal pay for equal work. There's also protections because it's a gender-based situation under the Connecticut Fair Employment Practices Act. That certainly is beyond the scope of what I want to chat with you all about this morning, but if there's questions about that, we can certainly address those at the end. So equal pay for equal work. There's also a statute that's been amended, adjusted based on this new pay equity law that we're going to get to here about discussing wages. In addition to equal pay for equal work, Connecticut also has a statute that prohibits employers from preventing employees from essentially talking about how much they make. A lot of folks actually don't know about this, which isn't really surprising because there are so many different laws out there that it's difficult for folks to stay on top of it all. But you cannot have in your handbook or a policy or something that says employees are not permitted to discuss their wages with other employees. They can inquire from the employer about what the wage range is for another position. You can't make an employee sign a document that says they're not going to talk about wages, they're not going to inquire about wages. These are all things, that are protected in Connecticut. And the idea behind it is, we want to make sure that we have equitable pay, across the board to the extent that we can. And if you deny somebody the ability to discuss this with other employees, that's going to kind of chill that ability to make sure we're not having, wage disparity issues. The big thing with these laws is it's against the law to discharge, discipline, discriminate, retaliate against, or otherwise penalize an employee who wants to discuss wages. I try to give as many real world examples as I can here. I had a recent situation with an employer where an employee was concerned about their status as tax or salary exempt versus hourly, and they were raising this concern with the employer. And this employee was disciplined for raising those concerns. And we have a potential issue now because it is against the law. If somebody wants to ask these questions, they are allowed to. So the last one, a little bit more on 3140. And it's important to understand this. So wage range versus actual wages are different. And so what all of these laws are concerned with is wage range for the position, as opposed to the actual amount that somebody is paid. And so no employer is required to indicate what Jonathan Bechtel makes per hour. But what you are required to do is present what the wage range is. And we'll get into that a little bit more. And if you do violate this section as an employer, there can be considerable damages. And one of the reasons why so many plaintiffs' attorneys practice in the area of employment law is because of this provision where the employee gets compensatory damages. That's the value of the loss of their job. But on top of that, they can also recover for their attorney's fees and costs, and also punitive damages to punish the employer for the wrongful conduct. The key is the piece on attorney's fees and costs. Most cases do not allow an attorney to recover their fees. Our employment laws, for the most part, do. And so when an attorney gets one of these cases, they're looking at the value of the attorney's fees that they may incur in presenting this case when determining how much it's worth. What that means practically for the employer is not only are they going to have to pay their employee to defend a case, if they lose, if they're unsuccessful, there's also the possibility that they may have to pay the plaintiff's attorney as well. Essentially, you're paying two attorneys as a result of your violation. That can get extremely expensive, extremely quick. And so it's important to understand where you can potentially go wrong as an employer and prevent it as much as you can. And then it's a 2-year statute of limitations to bring a case under that section. So in 2018, there was this act concerning pay equity that was brought into place. This is the third piece of it that employers need to be aware of. And this prohibited employers from trying to find out what a potential applicant previously made. You can't have a third party do a search into what their salary range was. They can't have any of that. The only way you can get that is if the employee volunteers that information to you. So that brings us to where we were prior to October 1, 2021. And just brief recap: equal pay for equal work, can't ask about salary history, and you can't prevent employees from discussing how much they make with other employees. That's all protected rights under Connecticut. That has all been adjusted somewhat as of this new law that has gone into place. And a few things have changed. So the basic overview of this act concerning the disclosure of salary ranges for vacant positions. It's a long way of saying you've got to tell applicants how much the job pays. It requires employees, you have to do it, to disclose salary ranges. Now, again, that's not the exact dollar amount that everybody in that job makes, but the range for that particular job. It extends prohibition on gender-based wage discrimination. We'll get into that. And it applies to both applicants and existing employees. So who does this apply to? They give us a few definitions in the new law. It's not as crystal clear as you may all would like it to be, but interestingly, if you have one employee, this applies to you. One of the things with employment laws, which is difficult for employers to keep track of, especially small businesses that don't have a dedicated HR staff, is how many employees trigger your obligations under different employment laws. So we've got this new law where if you have one employee, this applies to you. The Connecticut Fair Employment Practices Act kicks in at 3 employees. And then there are different FMLA, which is 75 employees, and all sorts of different numbers of employees that you have. But if you have one employee, this act applies to you. Anybody working for you for compensation. All right. So it's not necessarily dollars. 99.9% of the time it's going to be dollars. But anybody working for you for compensation, I'll spare you the tax definitions here and things. But the definition of income includes trading of services. And so arguably, if you have somebody come in, trade services with you, that's an exchange of compensation and could bring you within the purview of this act. But again, we'll stay away from the tax. No one's interested in tax law at 9 a.m. But again, wage range, this idea of wage range, it doesn't mean the actual dollar amount you're going to pay for the position, but what, $15 to $17.50 an hour, $25 to $30 an hour, whatever it may be. So here are your obligations under this new law. If you remember anything from this morning, this is the piece of it that you really want to focus on. So an employer is required, again, this is not optional, is required to disclose the wage range for a position to any job applicant before, at the time an offer of compensation is made. So if you're going to offer this person the job, you have to tell them what the range for the position is, or if the applicant asks you. So if you're in the initial interview process and this individual asks you what the wage range is for this position, this new law triggers your obligation to have that information ready and to provide it to them. So that's the first piece of this. Job applicants are afforded protections under this law, and current employees are also afforded protection. So once you hire somebody, similar to the first piece of it, you got to tell them what the range for this position is. If you change their position, promotion, demotion, lateral move, whatever it might be within the organization, you have to give them this new information at the time that the change is made. Or again, if the employee requests such information. Then the last big change with this new law is it changes this idea that I was talking about earlier, equal work to comparable work. which I personally think was not a smart move. It creates some more vagueness that we would always like to avoid. But unfortunately, that's not always the case. And if everything were crystal clear, my job security would be in question. So I guess maybe that's a good thing for me. But comparable work, that's going to create some issues in my opinion. So what does this all mean? We talked about this idea, and you've always got to love this. This is one of my favorite things, is when we put out a law and then we need to put out additional guidance to help us understand what the heck the law means when it's enacted. That always screams to me that we may have some potential issues if we need additional information to help understand the information that we're supposed to be complying with. So the Department of Labor has recently issued guidance to help us understand what this means, what our obligations are, and where we need to go from here. So who does it apply to? We talked about this idea of one employee, but that's not as simple and as clear cut as it should be. So an employer within the state seems pretty obvious, that's using the services of one or more employee for pay. It doesn't apply to a national company that hires Connecticut employees, unless that national company has a presence in the state. And so theoretically, especially in today's world with this remote environment, we could have a Connecticut resident working for a company that's located out of state, and they do not have protections under this Connecticut law. On the contrary, we could have an in-state company that hires only folks who live out of state. For instance, if you have folks from Massachusetts or Rhode Island, or really, again, with the new way that we can work anywhere in the country, if you've got a physical location in the state of Connecticut, this act applies to you. Everybody with us this morning, obviously is going to apply to them, but just some interesting nuance with who this thing does apply to. Oops. So like I said before, it protects job applicants. And again, you would think that this idea of who is a job applicant is, I guess, relatively clear, but it's not defined by the act. And it prohibits employers from coming up with your own definition of what a job applicant is considered. Really, the only guidance we're given is it refers to anybody who applies for a job, and we could construe or should construe this idea broadly. So what does that mean? Does it mean the person who walks in and sees the help wanted sign on the door and expresses interest in that job, is that an applicant? Or is it the individual who actually sits down and fills out the application? When do we need to provide this information to that individual? Based on the guidance that we're given, probably to the person who comes in and expresses interest in the job is the safest bet. And we'll talk about how do we put some of these things into place once we get there. But the frustration is we've got this idea of job applicants, but then we don't really know exactly who that applies to. Then we've got this idea of wage range. So how do we compute what is the wage range? Obviously, hourly information is going to be in there. But if you've got a situation where you offer a bonus structure or a commission-based structure, you have to factor that into this wage range and give that information to the individual applying. The actual ranges for current employees holding comparable positions, so that if this is an established job, you look at what the range is there between everyone's holding that job, you can use that. If you've got a budget for the position, that's also information that's going to be included in this wage range term. What it does not include, and this is important to understand, it does not include discretionary pay or discretionary bonuses. So for instance, if you have a situation at your employer provides a holiday bonus of some sort, and it's completely discretionary, that does not have to be included in this idea of wage range. But if you have a structured system for determining bonuses and commission, you have to take a look at what that has been and factor that in when you make this determination of wage range. So what about other positions? What if I come in and I'm applying in the idea of an office context, for a front office position, we'll use my firm as an example, our front office staff versus a paralegal. Can I ask how much the paralegal range is? And the answer to that question is no. This is limited for job applicants strictly to the job for which they are applying. Employees is a completely different situation. Employees are permitted to ask about other positions. So that's an important distinction to understand. Applicants are limited only to the job for which they are applying, whereas an employee is permitted to ask about other positions. If they ask you as the employer, you're required to give the range. You're not required to give the actual amount that somebody makes, but you are required to give the range. If the employee asks a fellow employee, that's permitted. The fellow employee does not have to give that information, but they're permitted to talk about it, and about other positions. That's the important piece of that. And again, it's important to understand you don't have to disclose the actual amount that somebody makes. You are never under that obligation to tell what somebody else actually makes, only this idea of what the range is for the position. So equal work versus comparable work. This is what I think is probably going to be the most litigious piece of this new legislation, because it's somewhat open to interpretation. So what the heck is comparable work? Again, the Department of Labor doesn't give us a ton of guidance on this other than to say, you look at various factors, and those various factors include a composite of skill, effort, and responsibility. All general terms, in my opinion. So it's going to be a process to try and figure out what is considered comparable work under this new law, as opposed to equal work, which I felt was a little bit more clear, because you could look at it on a job by job basis. Whereas now you could compare, different jobs, and they could arguably still be comparable work. An employer is still entitled to use geographic location, job applicants' credentials, their skills, their education, their training in making compensation decisions. So what this does not say is that you have to pay everyone the exact same amount for the exact same job. That's not the law. That's never been the law. It's not going to be the law. But what it does say is you've got to have some kind of scale here, and you've got to be able to justify why one person may be making something different than another person. And these are the factors that you can utilize in order to justify those decisions. And the burden is on you as the employer with all of this stuff. If you get a challenge to somebody from somebody regarding discrepancies in wages, the burden is on you as the employer to justify why somebody is being paid differently than somebody else. So that's the general overview of what we're dealing with today. I always find it better to open it up to questions. We've been at it for about a half an hour, which is as long as I ever like to talk, if I can help it, and especially via Zoom. But just to kind of wrap this up for you and some practical implications, you need to start putting a plan in place if you haven't already done this. This is in effect now. This applies as of October 1. To deal with these types of inquiries, you need to take a look at your job descriptions, review your job descriptions, update your job descriptions and make sure they're accurately reflecting what these various requirements of the jobs are, because those are going to have an impact in a number of different ways, but especially, with respect to this new law. And then handbooks are critical to a lot of organizations, and you need to update your handbooks to remove, I did this just the other day, to remove language that prohibits employees from discussing wages or otherwise tells employees that they're not entitled to this information. These laws are relatively new in the grand scheme of things, and oftentimes what happens is folks get their handbooks and that's it. They don't ever go back. They don't ever review. They don't ever update. And so things that may have been perfectly acceptable 5 years ago are no longer acceptable. And you need to make sure that you're updating, all of your policies, procedures, the way you go about things in order to comply not only with this new piece of legislation, but everything else that's been enacted over the past few years and everything that's on the horizon. We've got some things coming into effect at the beginning of the year as well. Which, like I said, I believe there are some serious topics on those. So I'm happy to open it up to questions and field those as we go, or answer anything else that you guys might have.
There was a question that came into the chat box, Jonathan.
Okay.
It says, Jonathan, there is a lot of reference to range. What is considered acceptable ranges? For an example, a range can be between 20,000 and 50,000. However, that is a wide range.
Great question. What is considered a range? So that's $20,000 to $50,000 is absolutely a wage range. What you want to be concerned with is being able to justify why there is such that discrepancy in that range. And then when you determine that spectrum, why somebody falls at a particular level within that range, and how do you justify it based on what we call bona fide criteria, as opposed to arguably gender-based. And so there is no definition. Like I said, they give us this guidance, but they don't tell us everything that we would want to know. There is no definition that says a wage range has to be between X and X amount of dollars. It's dependent on the position and dependent on you as the employer being able to justify why that range is, whatever it might be. You're welcome, Russ. Anything else? So this always makes me nervous because either I was fantastic or I was terrible, and nothing in between. So hopefully we'll go with fantastic.
If anyone has any questions, feel free to write them in the chat. If you are on the phone, you can send me an email. It is dsmith@middlesexchamber.com. Jonathan will be sending me over these slides, so I will be emailing them over to everyone shortly. Anyone doesn't have any more questions, I can wrap it up and have everyone have a good day.
And you have my contact information. And again, I'll send these slides over so that you have it. So if there's something else, is there another? What's Pam? So is disclosure required at the time of job offer? If no job offer, does it still have to be disclosed? Yes and yes, Pam. And so when you have an applicant for a position, you are required, if they ask you what the wage range is, at the time that they ask you, you are required to give it. So even if you don't intend to offer them the job and you've made the decision at that initial interview or when they're dropping off their application that, whatever, they ask you under the law, yes, you are required to give the range. And then if you offer the job, you are required to give it at the time the job is offered, whichever comes first. So it just depends, how that happens. But yes, even if there's no job offer, that information may still need to be disclosed depending on the circumstances.
Anyone has any? If not, if anyone comes up with any questions later on today, I will be sending over Jonathan's contact information. Feel free to email him if you guys have any other questions. I will also send the slideshows. Thank you so much, Sam, Abir, and Jonathan for speaking today, and I hope everyone has a wonderful day.
Thanks, everybody. I appreciate it.
Bye, guys.
Bye.